Right. Good morning, everyone. Welcome to the fall round of sessions in the Elder Law Training Series. The series is presented by Pro Seniors and the Ohio Department of Aging in collaboration with the Ohio Training Advisory Committee of the Alliance of Ohio Legal Aids. We had 5 excellent sessions in the spring on topics related to Medicaid and nursing homes, presented by Miriam Sheline. If you missed any of those sessions, I'll put the link to the recordings and materials folder in the chat in just a few minutes. After opening that link, you'll also be able to find a subfolder for today's session where we have the PowerPoint slides if you'd like to follow along. For the fall sessions, we are looking forward to hearing from more presenters from Pro Seniors on topics like veterans benefits, reverse mortgages, Medicare, and then today's topic on Social Security. The next session is on September 20th, where we will learn more about Medicare. So stay tuned. After the training, we'll send out a follow-up email and you'll get the link if you need to register for that training. A few logistics for today. The session is being recorded and the recording will be in that subfolder I just mentioned after the session today. There will be polling questions throughout the webinar today. If you are an attorney seeking CLE credit for this webinar, you will need to answer those polling questions. If you have trouble answering them in the pop-up that comes up when we say it's time for a polling question, please just put your answers in the chat and we will see those as well when we're compiling CLEs. At the end of the session, there will be a pop-up for a survey. Again, if you're an attorney seeking CLE credit, we need you to complete that survey. If you missed the pop-up window in that follow-up email later today, you'll have the link to get to that survey a different way. Now, turning to today's session, we are pleased to have with us attorney Mike Walters. Mike has managed the legal helpline at Pro Seniors in Cincinnati since 2006. He's been a practicing attorney since 1991. He serves as the chair of the National Association of Legal Hotlines and was recently presented with the 2024 Dennis Murphy Award for Outstanding Leadership in Legal Aid, presented by the Ohio Access to Justice Foundation. Mike's a frequent speaker on Social Security, so we are fortunate to have him with us today for this session. So take it away, Mike.
Thank you, Melissa. Good morning, everyone. I'm going to do just a quick commercial for Pro Seniors, and there is a point to this. Pro Seniors is a good resource. If you get a call from a client who is over the age of 60, and a lot of times with Social Security overpayments, they fall into either the category of people who are drawing retirement benefits. And of course, if they're younger than 60, it may be a Social Security disability issue where they've returned to work and they're being charged with an overpayment. But be aware that we're statewide. We only require that a person be 60 or older and a resident of Ohio. Those are the only categories of eligibility for Pro Seniors. So if you talk to someone who has a Social Security overpayment and they happen to be over the age of 60, by all means, please give them our statewide toll-free number here, and they will be scheduled with a free appointment. We'll talk to them. A lot of times we can recognize the cases that need to be sent back to legal aid, and we can kind of synthesize the legal problem and tell the client what to say to your intake staff when they call back so that they can get assigned to a staff attorney if it looks like it's an appropriate case for legal aid where the client lives. We have a pension rights department as well. It's a different phone number here. So if you happen to get a client, for example, that got a letter from Social Security that says you may be entitled to a pension, you can refer that client to the Pension Rights Center and they will schedule an appointment to have an attorney talk to them. We also have a senior Medicare patrol. So if you have someone who has an issue with possibly a scam, Medicare fraud, somebody's calling them, telling them that they want to do genetic testing on them and that Medicare will pay for it, that sort of thing, by all means, have that client call the senior Medicare patrol here at Pro Seniors, and our phone number here is on the screen. We emphasize services to veterans. So if you have a vet who has a problem with the VA, pension problem, overpayment, by all means, as long as that person's 60 or older, refer them to our main number at the helpline number, and we'll schedule an appointment to have one of our attorneys talk to the client. Just as an example of a recent issue that we dealt with, there are 2 state veterans homes in Ohio run by the Department of Veterans Services, and they had decided to adopt a policy that if they thought a veteran who was applying for admission to one of these 2 facilities, one's in Georgetown, one's in Sandusky, and they thought that veteran had diminished capacity, they were proposing a rule which would have required that someone, I'm not sure who, was supposed to step forward and file for guardianship against that veteran, have that veteran declared incompetent before they would accept the veteran as a resident of their facility. We did not, thankfully, have to litigate that case. We used advocacy with the Department of Veterans Services, pointed out that this was probably a violation of the Americans with Disabilities Act, and they pulled the rule. We did that in conjunction with other legal aids, with Disability Rights Ohio, and with the state long-term care ombudsman program. And so that is the kind of impact litigation that we try to look for, in particularly in connection with veterans. Long-term care ombudsman program, those are always local where you're at, but we're extremely fortunate here in Cincinnati to have a long-term care ombudsman program housed here at Pro Seniors. These are a wonderful resource that you should connect with in your area to get referrals for clients that are the most vulnerable folks that you could possibly imagine, folks that are in nursing facilities who might be charged with a overpayment on Social Security, might be facing a discharge from a nursing facility. These are the most kind of critical problems you could imagine on a legal problem. And I would encourage you to reach out to your local long-term care ombudsman and work with them on having a referral system so that they can get cases sent to you when they're trying to help a senior who has a legal issue. This is our website. I wanted to point out a couple things that are on the website that would be useful for some of what we're talking about today and some of the other programs that we've talked about. On our homepage, there is a drop down that says resources. And within that drop down, one of the drop downs says Medicare, Medicaid eligibility. That is more than just Medicare and Medicaid numbers. It also includes, for example, the SSI federal benefit rate for each year. It includes Medicare savings programs where the state will pay for the person's Medicare premium and the income levels for those. And all those numbers are kept up to date by our staff. And it's a good place to go if you need to look up a current number on eligibility for a particular public assistance program. We also have fact sheets. So if you, on that same resource tab that I showed you on the last screen, you drop down under resources to fact sheets. You will see pamphlets as the old term that we use for fact sheets. And you can click on that to get a list of pamphlets, which are organized by subject matter. So for Social Security, disability pamphlet, the Social Security retirement pamphlet, the Social Security overpayment pamphlet are all listed under public benefits on our website. Now, I was asked to do both Social Security basics and Social Security overpayments. Social Security basics is an extremely complicated subject. No way you could do it in 90 minutes. So I'm going to just kind of breeze through this, but I'm happy to take any questions. I'll take a break for questions at the end of this section. One of the things that I wanted to mention was the distinction between SSI benefits and SSDI benefits, because you will get calls from clients, and I frequently get this question from lawyers. How can I figure out exactly what this client is getting? Because clients don't always know the correct terminology for their benefit, and they'll tell you they're getting SSI when in fact they're getting SSDI or vice versa. And so it's important to understand the distinction between these two programs. Supplemental security income is not a Social Security program in the sense that it is funded through the trust funds. It comes instead out of general taxpayer revenue, just like Medicaid benefits, SNAP, and those sorts of programs. But it is administered through Social Security offices. The rules are a lot different than they would be for a typical Social Security situation. For example, SSI is means tested. It's based on income and resources. Countable resources are not necessarily all of your resources. Many resources may not be countable for one reason or another under the Social Security rules, but your countable resources must be $2,000 or less to be eligible for an SSI check. There is a general eligibility, which is either that the person is 65 or older, or Social Security has determined them to be disabled in order to qualify for an SSI check in the first place. So regardless of financial eligibility, you have to be either 65 or you have to be adjudicated as being disabled by the Social Security Administration in order to be eligible for an SSI check. Current federal benefit rate for an individual is $943 a month, $1,415 if you happen to have an eligible couple that you're talking to. So when you have a client who tells you that they get SSI, they may be referring to SSDI instead. SSDI stands for Social Security Disability Insurance. It is a benefit based on paying into the system, similar to retirement benefits. It is not means tested, and it's paid later in the month. If the person happens to be on a public assistance program like Medicaid, or they get an SSI check, then their Social Security check will come on the 3rd. But if they're not on a public assistance program, their Social Security checks are paid on a Wednesday of the month, determined by their birthday. So it might be 1st, 2nd, 3rd, 4th Wednesday of the month. And it is possible, because SSI is considered a supplement to people with low income, that a person can get both Social Security benefits and SSI. So when you're talking to someone and you're trying to discern what sort of benefit that they're receiving, you need to know a couple questions will generally tell you. What day of the month does the check come? If it comes on the 1st, it's SSI, or at least part of what they get is SSI. If it comes on any other day of the month, it's Social Security, not SSI. Second question, how much is the check? If it's more than $963 a month, then you know for sure that it's not SSI, that the person is on Social Security only. And because of the difference in the rules on means testing versus non-means testing on Social Security disability insurance, it is important to know when you're revising a client what kind of benefit they're on. Have my first poll question here. So you're talking to a client who's 47 years old. Client tells you, I get SSI. So he asks a couple questions, and he tells you that he gets a check on the first day of the month of $300, and then he gets another check that comes on the 3rd of the month for $663. And the question is, what can we conclude from the information that you were given by that client?
All right.
Options being client receives SSI only, client receives SSDI and SSI, or you need more information.
All right. Got about 75% of you participated, so we'll give everyone a few more seconds and then we'll shut down the poll. Okay.
Excellent. Excellent. 87% said SSDI and SSI, and that is correct. you can assume someone who is 47 years old and gets a Social Security check, Social Security versus SSI, is getting SSDI. And the fact that he receives 2 checks during a month, SSI coming on the first, the other coming on the third, and they happen to add up to 963. The reason SSI federal benefit rate is 943, but if you have other income is 963, is because there's a $20 general exclusion for income under the SSI program. So they never count the first $20 of income. And so if you have someone who gets 2 different sources of income and they get SSI, you will see that it adds up to 963 a month. Now, Social Security is based on credits, quarters of coverage. And for retirement benefits, you need 40 quarters of coverage. The point of this is the Social Security Act presumes a person's working life is 40 years, age 22 to age 62. Now, it doesn't mean that you can't use earnings or earned before you were 22 years old, or that you can use earnings that you were earned after you were 62 years old. But when determining how much your Social Security benefit is going to be, they're using a basis of 40 years of work. That's the presumption. And the years of work translate into 1 quarter for every year of work during a lifetime to be insured for Social Security benefits. So if you're filing for retirement benefits because you're 62 years old or older, you're going to need 40 quarters, 10 years of work. The maximum you can earn in 1 year is 4 quarters. And each quarter this year is 1,730 to earn a quarter. So if you work and earn over 6,920 in 2024, you'll be granted the 4 quarters. I should mention quarters of coverage for disability benefits, because I know a lot of legal aid programs, majority of your calls may come from clients on disability. Think of onset date, established onset date of the disability, as if it's the end of the person's working life. So if a person is 48 and they're determined to be disabled at that age by Social Security, then you're doing the same calculation, age 22, but instead of age 22 to 62, you're going to age 22 to age 48. So that's 26 years. So that person would need 26 quarters of coverage. I'm not going to go into this, but there is a special requirement for insured status for disability benefits that requires that you have a 5 out of 10 year work history within the 10-year period prior to the onset of your disability. So if someone's filing for disability, they're going to look at their earnings record for the 10 years prior to onset date, and they're going to want to see half of those quarters, 20 quarters out of 40, that the person has coverage in order to be eligible for disability benefits. Retirement benefits, everything in Social Security is based on the worker. So whether you're filing as an auxiliary, as someone else on another record, it's based on the worker's work history as to determining how much the check's going to be and whether the person's eligible and whether there's enough quarters of coverage. You can get Social Security retirement benefits as early as age 62, but they're reduced because you're taking them, quote, early. Everyone has a full retirement age, which has been gradually raised to age 67. So most people born 1960 and later are going to have to be 67 before they're considered full retirement age by Social Security. People right now may have a retirement age anywhere from 66 to 67, depending on what year they were born. If you take benefits before that period of time, there is a reduction. To make it short, it's 0.5 of 1% for every month that you take it before full retirement age. You can just make an assumption it's roughly 0.5% reduction per month for every month that the person takes the benefit before their full retirement age. A spouse can get benefits on the record of another spouse. So if person is not insured for Social Security, or they're insured for a very small amount of Social Security, they can file on their spouse's record. They must be 62, just like you would if you were filing for retirement. Or alternatively, you can receive benefits on a worker's record if you're caring for a child who is under the age of 16 or has been adjudicated as disabled by Social Security. Divorced spouses can potentially be qualified for Social Security benefits on the record of an ex-spouse, but there is a requirement that they be married for at least 10 years. There is a second requirement for spouses, which is a distinction from widows. I'm going to get to widows in a minute. For spouses, you must be unmarried. So even if you were married to someone for 20 years, if they're still alive and you go to Social Security and say, I want to file on my ex-spouse's record, if you're married to someone else, they're going to deny that application because you're remarried to another person. You have to be unmarried to qualify. Children can draw benefits if they're under the age of 18. There is a short extension if the person happens to be in high school. When they turn 18, they can continue until they finish high school. And there are disabled child's benefits that are available if the child establishes that they became disabled before they were 22 years old. Potentially, you will occasionally see cases where someone's developmentally disabled, for example, and is drawing disabled child's benefits on the record of a deceased parent, and that person may be 40 or 50 years old because they've been drawing benefits for 30 years. Spouse's benefit is the basic concept of Social Security calculation and how much you get is what's called the PIA, primary insurance amount. So if you're looking about a benefit for a spouse, you're comparing their own PIA, what this person paid into Social Security during their lifetime, and you're comparing that to 50% of the other spouse's PIA. And Social Security doesn't pay both, they pay the difference. So as an example, person has a PIA of $1,200 a month. They're also married. Their spouse is drawing Social Security. Their spouse's PIA is $2,500 a month. Half of $2,500 is $1,250. Their own PIA is $1,200. So in that case, if they filed on the spouse's record, they would get that $50 a month extra as a spouse, the difference between their PIA and 50% of their spouse's PIA. But again, remember, when I say spouse, I'm talking about your spouse is alive. Widows, different. Widows. First of all, widows or widowers are working from 100% of the deceased spouse's PIA, not 50. Secondly, eligibility for widows benefits or widowers benefits is as early as age 60, just based on your age. And you can get widows or widows benefits as early as age 50 if you're adjudicated as disabled. Obviously, just like with living spouse, you can get benefits for caring for a child under 16 or if the child's disabled. Unlike spouse's benefits and remarriage, if you remarry as a widow or widower after the age of 60, it does not disqualify you from getting widows or widowers benefits. So if you have someone who has a deceased spouse that they were married 2 years ago or that they were divorced from who's deceased, and that person happened to have married after the age of 60 to their current spouse, they can still file for widow's benefits on the record of the deceased spouse. And generally, as I say, they're working from 100% of the PIA. So you would normally expect when someone calls you, says, my spouse died, what am I going to get from Social Security? The question you ask is, what was your deceased spouse drawing? And that's usually going to tell you how much they're going to draw. That could change slightly if they're not yet full retirement age because of reduction for taking it early. But a crude rule of thumb is that a widow or widower's benefit is going to be approximately what the deceased spouse was getting in Social Security when they died. So going back to the example of a spouse versus a widow or widower, Fred and Alice both paid into FICA. FICA is the old term for Social Security tax. Fred receives $2,513 a month Social Security benefits, and that's his PIA. He got that at full retirement age. And Alice receives $1,400 in Social Security benefits. That's her PIA. She waited until she was full retirement age to take it. Half of Fred's is $1,256. That's less than Alice. Therefore, there's no eligibility for spouse's benefits because her own Social Security is more than half of her spouse's benefit. Calculating benefits. Again, this is based on lifetime earnings. On retirement benefits, you always drop the lowest 5 years. So you're going to end up averaging the high 35 years of someone's working life to determine how much their Social Security benefit is. Earnings are indexed. So a formula is applied to earnings back in the 70s and the 80s when earnings were much lower. And those are compared to what workers are making today. And each individual year that a person worked is then indexed to bring it up to a level that's more equivalent to what people are earning now. And after all that's done, Social Security is going to pick up the high 35 years of work, and they're going to average them to a 12-month amount, a monthly amount. That's what's called your average indexed monthly earnings. That's what Social Security is working from to determine how much your Social Security benefit is going to be. But you're not going to get 100% of your average index monthly earnings. Social Security is progressive in the sense that the calculation of the actual PIA, the check that the person's going to get, is based on a percentage of their average index monthly earnings. So if a person's average index monthly earnings are, let's say, $1,000 a month because they were a low income worker, they're going to get 90% of that is going to translate into their primary insurance amount, what they would get at full retirement age. As your average index monthly earnings get higher, then the percentage that you get a return on gets lower. So anything, and I don't have the bend points in front of me, but probably once you get much over 1,000, it's going to be 32% instead of 90%. And then if you get above 2,000, I'm just making those figures up, it goes down to 15%. So the idea being that lower paid workers receive a larger return in connection with their average index monthly earnings than a higher paid worker. And this is an example. Somebody who's low income, 20,000 a year, might get a Social Security check of $989, which translates into 57% of their average index monthly earnings. Middle income worker making, say, 41,000 a year is getting a 44.5% return, and a high income worker is getting a 32% return on what they paid in. Medicare coverage. Medicare is triggered by one of two things. Either the person is 65 or the person is receiving SSDI, not SSI, and has been receiving that or is eligible for SSDI for 2 years, 24 months. That's when your eligibility for Medicare coverage is triggered. And if you're getting Social Security benefits already when that happens, you're automatically going to get a Medicare card in the mail. It's going to be Part A, which is hospitalization coverage, and it's going to have Part B, which is outpatient treatment. And then under the prescription drug rules, you have to go out and find your own prescription drug coverage through what's called Part D Medicare. But what happens sometimes with us at Pro Seniors when we get calls is if you don't enroll in Medicare at your first eligibility, age 65, and someone may have not decided not to take it yet, you will be penalized for not enrolling at your first eligibility. You will have an enrollment period, which may delay when you can get into the system, and they will charge you more for the premium because you didn't take it at the first eligibility date. The reason for all those rules is this is an insurance program, and people that are 65 in comparison to people that are 90 are getting less medical treatment. So when Social Security, federal government determines the Medicare premium, they're taking into account what they expect they're going to have to pay out, and the premiums are supposed to cover that. So if you're not enrolling at the earliest eligibility, then you're not paying in when you'd be less likely to use it. Therefore, they're going to penalize you and charge you more for it if you enroll later. There is a large exception for that, which is that if you have group health insurance coverage and you're still working, then they will allow you to enroll without a penalty if you sign up when your employment status changes. So it's not merely that you have insurance through work, but it's also that you're an active employee. If you have both of those things, then you can sign up for Part B Medicare later, as long as you show Social Security, you had group health insurance, and you were still working. You can get Medicare coverage on not just your own work record, but on the record of a spouse if you didn't pay into Social Security, whether you're a widow, widower, or of a spouse of a living person, with the same kind of qualifications that you have to have been married for at least 10 years if you're divorced. And you can file for Medicare coverage even if you're deferring taking your Social Security benefit because you want to build up the monthly amount of it. But you have to know to contact Social Security when you're 65 to at least determine whether you're going to have an issue with signing up for it late. I strongly encourage people to go to Social Security's website and set up a My Social Security account to file, because since COVID, Social Security offices, as anybody who's dealt with this knows, almost impossible to get a hold of anybody at the office, almost impossible to get a live person on the phone. Getting an appointment to file for Social Security benefits can be difficult, sometimes to the level of being nearly impossible. And so if possible, when you're talking to a client who wants to file for Social Security, talk them through the process of them setting up a My Social Security account online at Social Security's website, which will allow them to file for either retirement or disability benefits online. You can file for benefits up to 3 months before the time that you're first eligible or that you want the check to start. On to my next poll question, which is, when is Medicare coverage effective? Go ahead, Melissa. Is it when a person goes on Medicaid? Is it age 65 or on SSDI for 24 months? Or is it the date the person goes on SSI benefits?
All right, we have about 70 folks responded, so we'll give everyone a few more seconds and we'll shut down the poll.
93% correct. As I said in a previous slide, Medicare eligibility is triggered by one of two things, either being age 65 or being on Social Security disability benefits for 2 years. So excellent. Now, I'll stop for questions. That was a lot of material to cover. I am more than happy to take questions. I don't think we're in any danger of running out of time here. So I assume you have them, Melissa, in the chat.
Yep, we do have a question in the chat. Michelle asked, when is a DAC/DIB eligible for Medicare?
That also, I apologize, when I said SSDI for 2 years, that also includes child benefits. And that would be also 2 years, I believe, of receiving disabled child's benefit on the record of a parent when the Medicare coverage would kick in.
Okay. Other questions? I don't see anything in the chat right now, but feel free to put those questions in the chat.
I'll stop for a minute just in case anybody wants to ask anything. Okay, I'm going to go on to overpayments. By the way, I want to credit Justice and Aging for a lot of these slides. I use them with permission from other presentations Justice and Aging has done on Social Security overpayments. This is one of the more difficult situations you're going to deal with a client, because particularly with seniors, but true absolutely with disabled people, most particularly if somebody gets an SSI check. If someone is facing a cut in their income and it's their sole income, the potential consequences of that can be catastrophic. And so when you're dealing with someone who has an overpayment, even if it doesn't seem like it's a lot of money, particularly if you're talking to someone who has SSI benefits, I would encourage lawyers, legal aid programs to go out of your way to do what you can to help those folks, because even a small cut in their income can have potentially catastrophic effects, which will cause other legal problems that you're going to have to deal with later, bigger legal problems that you're going to have to deal with later. So if you can catch that at the beginning of a problem before it leads to other things, you're not only helping the client, but you're potentially helping your program with not having to deal with a much more catastrophic situation later on. So an overpayment occurs when a beneficiary receives more benefits than the amount they're entitled to in a given month. If the individual is currently receiving Social Security benefits, Social Security is going to withhold the funds from the current benefit to repay the overpayment. That's the general principles. What kind of overpayments are you going to see? SSI benefits. I'll just mention a couple cases I've seen recently. Client somewhere way up in Ohio was beneficiary of a trust left for her by her deceased mother, and she was not the trustee of this money. It was a testamentary trust. I think it was her brother who was the trustee. And Social Security at some point decided that the trust was a countable resource, cut her off of SSI. The lady is getting no benefits from anybody. The last time I talked to her, she was at an administrative law judge hearing. We were trying to give her some pro se advice, because I can't represent people outside Greater Cincinnati, on trying to persuade the administrative law judge that this trust was not a countable resource because of what the Social Security regulations say. Living arrangements happen a lot. Living arrangement situation happens quite frequently with our clients at Pro Seniors because they're 60 or older. If you're getting an SSI benefit, the idea behind SSI is it's supposed to cover personal needs, rent, food, shelter, that sort of thing. If a person goes into a facility covered by Medicaid, then the Social Security rules cuts that person's SSI check to $30 a month. And so we'll see is the long-term care ombudsman will walk down the hall. They've got a client who's been in a nursing home for 6 months. Social Security just figured this out, and they get a letter from Social Security that says they've been overpaid because Social Security was paying them $943 a month SSI when in fact they should have only been paying them $30. Government pension offset is probably the most frequent kind of call I get. It's kind of a niche because of the fact that our clients are 60 or older, but you should be aware of it. The issue is if a person paid into a pension system through a government, which can be federal employees, state employees, also school employees, school teachers, and employees of school systems. Historically, government workers were not covered by Social Security tax and still aren't in most cases. And Social Security has rules that say that if a person gets a pension based on non-covered employment, that pension will negatively affect not just auxiliary benefits if they file on it as a spouse or a widow or widower, but also even their own Social Security benefit is reduced if they get a non-covered pension. And many times Social Security won't figure this out until years after the fact. And it's very common for me to get calls from people who have a letter from Social Security that says that they're overpaid $80,000 or sometimes more because they've been drawing a full survivor benefit and Social Security just figured out that this person is retired from the state of Ohio and they get Ohio Public Employees Retirement System pension and they're charged with an overpayment because of the offset. Excess earnings, if you're not full retirement age or in the year before you turn full retirement age, there is a cap on how much you can make before Social Security starts withholding some of the checks. And right now for retirement benefits, I think it's around, I'm using round figures, somewhere around 22,000. If you make more than that, it can affect the eligibility for retirement benefits. The legal aid folks on this call have already experienced plenty of calls about people that were receiving Social Security disability benefits and went back to work. Social Security has work incentives built into the law, but once you get beyond those work incentive periods, Social Security will literally terminate your disability benefits. So for the first 9 months, if a person goes to work and they're drawing SSDI, they won't cut their check at all. It's the idea being it's called a trial work period. They'll give them a chance to go back to work and see whether they can do it. After 9 months, you go into what's called an extended period of eligibility. That's a 3-year period where if you go over substantial gainful activity amounts, you don't get a check, but any month that aren't making substantial gainful activity, you do get a check. But where it gets to be a serious issue is beyond that 36 months extended period. If they go back to work and they make over substantial gainful activity amount, right now is 1550, even for 1 month, they are no longer entitled to the work incentive rules. So Social Security is going to send them a letter telling them that they're terminating their disability benefits. The good news is Social Security has what's called expedited reinstatement. Even if you go back to work and you make over substantial gainful activity after that period, but there's a huge overpayment because Social Security is going to say you weren't due checks for this period after your extended period of eligibility ran out, and therefore you're overpaid all the benefits that you received until you actually stop work. So what are your options if you're dealing with a client, trying to give advice to a client who's facing an overpayment? Well, number one, they can request a reconsideration. Reconsideration says Social Security, you're wrong, I'm not overpaid. Or alternatively, Social Security, you're wrong, I'm not overpaid as much as you claim I'm overpaid. So if you disagree with either the fact of the overpayment or you disagree with the amount that Social Security claims that you owe them, that's a reconsideration. And I'll talk about how to do that online in a different slide. Alternatively, you can request a waiver. Waiver says, Social Security, I might really be overpaid the amount you say I am, but I can't afford to pay you back and it's not my fault. You can always call Social Security and ask that they take less from the check if they're proposing to collect an overpayment. And obviously you can do nothing, and I'll explain what happens when you do nothing. And I'm not going to talk about bankruptcy, but be aware that you can discharge a Social Security overpayment in a Chapter 7 bankruptcy. Social Security's collection system on overpayments is what I call passive aggressive, in the sense that it puts the burden on the claimant to do something. Everything else is programmed into Social Security's computer system. So when someone determines that there's an overpayment, that Social Security employee is going to put that overpayment amount into the computer system. That's going to create a couple of things. The person's going to get a letter saying you're overpaid. The person's going to be told you have the right to contact us and file either reconsideration or a waiver. The letter is going to demand all of the money be refunded. And if somebody doesn't intervene at the Social Security office, the next step is they're going to get a letter automatically withholding the amount, the default amount that Social Security wants to withhold. And I'm going to talk about how that's changed. So all of that is automated. When you have a client who gets a letter from Social Security, almost never is that written by a live person. It is based on the codes that were put into the computer, which causes the computer to spit out the notice. So understand that garbage in, garbage out. A lot of times when you're looking at a notice that doesn't make any sense, it's because whoever at the field office made the inputs into the computer, did something wrong, which created this letter, which might not make any sense. An overpayment notice looks something like this. If you think we're wrong about the overpayment, you can appeal it. You have 60 days to file an appeal. You can request a waiver. If you request waiver, would need a statement of your income and assets. If you request within 30 days, the overpayment will not have to be recovered until the case is reviewed. This paragraph is a bit misleading. Social Security is always supposed to stop withholding going forward if the person files an appeal, reconsideration, or a waiver request. What this particular paragraph is telling the person is that if you want to stop us from attempting to collect it from the get-go, you need to file an appeal within 30 days. That doesn't mean that if you file an appeal in 60 days on a reconsideration, they'll stop withholding at that point. They just won't refund what they've already collected. And the old days would have this paragraph at the end. If we do not receive your refund within 30 days, we will hold back your full benefit, starting with the payment you would normally receive about December 24th, 2014. This is an old letter, obviously. We'll continue holding back your benefits until we recover the overpayment. Note that I used to get clients all the time, particularly government pension offset cases, where it would say, beginning next month, your benefit is going to be zero. And it would say, beginning in October of 2032, your benefit will resume at $500 a month. In other words, the computer was programmed to take the whole check, including the Medicare premium, so that their Medicare wasn't getting covered, if they didn't do something to contact Social Security and either appeal it or negotiate some kind of withholding amount. And when I'm talk about at the end of this presentation, some of the changes, one of the changes is that it is no longer defaults to 100%. It is now 10% of the check instead of 100. So reconsideration challenges the fact of the overpayment or the amount, has to be filed within 60 days. Almost all of Social Security's deadlines include a 5-day tolerance for mailing time. So when you see a 60-day time limit, you can probably add 5 days to it. One of the things that I will deal with frequently and other attorneys is by the time the client contacts you, you're looking at a letter, it's more than 60 days in the past, and it's not clear whether they can file a reconsideration because it looks like it's too late. If Social Security is still working on the case, it is just as likely as not that they will get more letters. So if something else happens, they get a new letter. When the new letter comes out, because again, these are computer program letters, it is more common than not that it will include a paragraph that says that you can file a reconsideration. So sometimes if you're dealing with a case where the statute of limitations on a filing an appeal is expired, if Social Security is currently working on the case, sometimes strategy is let's wait till you get the next letter, because the next letter that comes out is going to give you another 60 days to file an appeal, and then we can do it. The Social Security appeals form is linked here. It's a PDF, fill in, but Social Security now allows online filing of reconsiderations, even for post-eligibility issues. And I have found it to be a total blessing with clients. It's very quick. It's very easy. You just go to Social Security. If you Google Social Security reconsideration or go to their website, you can file the thing online. And the benefits of that include the fact that you're not having to get a signature on the documents, fax them to the local Social Security office, worry about whether they're going to lose it or can't find it, worry about trying to prove that the client filed it on time. You do it online. You got absolute electronic proof that it was filed, and the client will actually get an email confirming receipt of the appeal. So it's very easy later on if you get into a dispute with Social Security about whether an appeal was filed to prove that it was filed if you do it electronically. Waiver is, again, a different way of approaching an overpayment. It's saying, number one, I'm not at fault in causing the overpayment. It was Social Security's fault. They messed up the math or they did something wrong in a computer. And in addition to that, because you have to prove two different things, I can't pay you back. Paying you back would be a hardship. There is an exception for what's called against equity and good conscience. I'm not going to go into that, but against equity and good conscience generally requires that the person change their position for the worse because they relied on a Social Security benefit, went out, and I had a case last year with a hearing where the client went out and bought a new car and was now facing this overpayment problem. And one of the things I argued to the administrative law judge was that she changed her position for the worse. So even though she didn't meet the test that her income and assets were super low, that she couldn't pay it back, alternatively, she met the test because it would be against equity and good conscience to collect the overpayment. There's a link here to the actual rules on against waiver and the form itself, which is an SSA 632, which has been simplified since last year. It's much easier to fill out than it used to be. And I'm going to get to this. Social Security has promised to simplify it even further to make it easier for clients to file for waiver requests. Fault. So when you're trying to prove without fault for purposes of a waiver, Incorrect payment resulted from an incorrect statement by the individual, which he knew or should have known was incorrect. Failure to furnish information, which person knew or should have known was material, or with respect to an overpaid individual only. Acceptance of a payment, which his person knew or should have known was incorrect. So when you're talking to someone who has a Social Security notice that says they're overpaid, you need to get a copy of the notice. I know it's aggravating. I know clients lose things, but it's almost impossible to give a client advice about how to deal with an overpayment based on the client's subjective description of what they think happened. So by all means, do everything you got to do to try to get a copy of the notice. What do you need to see on the notice? You need to know what's the amount of the overpayment they're claiming. When is withholding supposed to start according to the letter? And is there an explanation? As more commonly than not, there is not an explanation on these things, which is always a basis to file an appeal. It will at least stall collection if you file an appeal on the basis of the fact that Social Security hasn't even told the person why they're overpaid in the first place. The second prong of waivers is that paying it back would be a hardship. One of the things you need to know is if your client's already getting cash public assistance, you don't have to prove that second prong. It is presumed that person is unable to repay the overpayment. So you have a client who's getting cash assistance, SSI benefits, TANF, TANF benefits. That person is VA pension. That person is presumed to be unable to repay. So when you get to the waiver form and it's got all the complicated information about what's your income, what are your assets, the question right before that starts, ask if they're on public assistance. And if that question is answered yes, you don't need to answer the rest of the questions. You can line them out or leave them blank and submit the waiver form without the financial information. That does not apply, however, as of the moment to SNAP. So the fact that someone is on SNAP does not automatically mean that they are deemed unable to repay the overpayment. That is theoretically going to change. That's one of the things that I've heard that Social Security is thinking about expanding the rules on what they treat as public assistance for purposes of a waiver program. You always have to look at the notice itself. If you're trying to get in touch with the Social Security office or you're trying to refer your client to get in touch with the Social Security office, the notice itself will have a paragraph towards the end which says, if you have any questions. It goes on to give you some more information. And then it will go on to say you can write or visit any Social Security office. The office that serves your area is located at. And then it will then give the name and address of the servicing field office. Servicing field office is determined by where the client lives, their zip code. In that same paragraph, in the past, and I'm going to cross my fingers and hope it continues, they usually put the number of the servicing field office that handles that person's claim, not the national 800 number. So if you look in that paragraph where you see it says, the office that serves your area is located at, and it gives an address, that same paragraph should give you the phone number for the local office. One tip I will give legal aid programs is that when you talk to a client and you're dealing with a local Social Security office and that client either has a number or through your own work you get a number, save that number so that the next client that is served by that office, you've got their phone number so you can reach them if you have another client dealing with that same office. The Social Security field office locator, which is on this link, will then take you to an option where you can locate an office by the zip code. So you type in the zip code of the client. But Social Security has now gone back to the pre-COVID rules where when you go to the field office locator and you try to find the office that deals with that client's address, it's most of the time going to give you the national 800 number. It is not going to give you the local office number at the Social Security office you're trying to reach. All right, I'm going to stop for questions. Again, a lot of material. I am more than happy to take any questions anybody's got. Go ahead, Melissa.
All right. No questions in the chat right now, but feel free to put them in the chat. Or if you want to unmute yourself, I think we could do that too.
Sure, that's fine.
All right. Last call.
All
What are
right.
your questions?
We may end up early because I was
Oh.
guessing I was going to. Oh, we have a question. Go ahead,
Yep,
Melissa.
there's a question. How many checkpoints are there? Or were there?
Checkpoints? I don't understand the question. Please
Oh,
ask the
Susan,
person.
are you asking about how many polling questions we've had? Okay, we've had 2 polling questions so far.
Yeah, there's one more coming. One more coming.
Okay.
All right. We may end up early because I was assuming I was going to get a lot of questions. Now, Social Security, thankfully, has decided that maybe they were getting some bad publicity about their overpayment process, particularly the fact that people were having their entire check taken. There was a 60 Minutes piece on an overpayment case maybe a year and a half ago in which someone was on their deceased parents' record when they were a kid, and they file for benefits 20 years later, they're disabled. And Social Security said, ah, you know what? You're overpaid from back when you were 15 years old because your parent made too much money or whatever the problem was. And they proceeded to take the entire Social Security check that person was due. They were living on no income. And there was a lot of that kind of stories that were going around out there that brought a lot of bad light on the Social Security Administration. I should say I was a claims representative in a former life. I was claims representative with Social Security from 1979 till approximately 1990. I actually went to law school at night while I was working at Social Security. So I try to be sympathetic to them. But their overpayment process was just absolutely Kafkaesque. And the fact that it was defaulting to taking a person's entire Social Security check created absolute mayhem for people that were receiving Social Security benefits that were notified of an overpayment. What was worse, and I had this happen so many times that I actually have a pro se memo that I would give clients who called the helpline where this happened, was the Social Security's manual told them that the Medicare premium was the highest priority for collection. So when you read Social Security's manual and it said it at multiple different places, it would tell the Social Security Administration that when they were collecting an overpayment, to leave the Medicare premium in place so that the person, and it even said in the manual, so that a person didn't lose their Medicare coverage at a time when they're losing their income on top of it. But the computer program defaulted to taking the entire check, including the Medicare premium. So what would happen is somebody would get one of these notices that says they were overpaid. Social Security stopped their checks. A lot of times, if I'm dealing with a government pension case and the Social Security benefit was very small, person, okay, go ahead, take my check. I don't care. But what they didn't realize was their Medicare premium wasn't getting paid anymore. And a year and a half, 2 years later, they would get a letter from the Center for Medicare Services that says, you haven't paid your Medicare premium in 2 years. We're going to terminate your Medicare coverage. So it was just complete chaos. primarily because of the way the computer was programmed. Now, Social Security's new rule is to default to 10% of the check rather than 100% of the check. And that is a huge relief for clients who are dealing with an overpayment. There's a link in here to the emergency message, which is in Social Security's policy manuals, all of this stuff that I'm linking in here. Anything related to Social Security's manual is public. Went into effect on March 25th. And beginning in June of 2024, supposedly any new overpayment would default to this 10% withholding. So what I said before about computers programmed to send out a letter, you're overpaid. And then if nobody makes an input into the computer to stop anything, the next step would be the computer would send out a letter saying, we're going to take 100% of your check. Supposedly now, since June, any new overpayments that occur for the first time, that default letter was going to be 10%, not 100. I will say that I have seen cases that didn't comport with what Social Security said was going to happen. So even if it's a new overpayment, you should not assume that they're only going to take 10%. You need the client to get the letter that tells them that they're going to start collecting, and you need to confirm that it's only 10% of the check and not 100%. Worse, anyone who was already overpaid, who was in full withholding because of a previous overpayment prior to June, they were not automatically going to stop taking 100% of these folks' checks. Supposedly, there was going to be a letter sent. I have never seen any client that got one of those letters that said you had the right to call us and ask for lesser withholding. So if you're talking to someone who's already got an overpayment that occurred prior to June of this year, it is more likely than not that they're taking their whole check to collect the overpayment. So I've got a hypothetical here. Mr. O calls you because he has no income. He was getting Social Security disability benefits. He went back to work. He worked long enough that he was outside of extended period of eligibility. And then he went over substantial gainful activity amount for 1 month outside of the work incentive rules. And Social Security sent him a letter that said, we're cutting off your disability benefits because you're engaged in substantial gainful activity. He then goes back to Social Security and says, well, wait a minute, I stopped work. And they put him back on Social Security under these expedited reinstatement rules, but he has a $20,000 overpayment. Social Security is collecting the entire check because of the fact that he owed them $20,000 because of the fact that they terminated his disability. His gross Social Security check was $2,000 a month, but the entire amount is being withheld to collect his overpayment. So this is, I will warn you, it's kind of a trick question. What should Mr. O do first? Should he file a reconsideration? Should he file a waiver request? Should he file for SSI benefits? Should he call the 800 number?
All right. Got about 70% answered, but it looks like some of you are changing your minds. The answers are jumping around a bit, which is fine. I'll give you 10 more seconds to answer the poll, and then we'll shut this one down. Okay, there you go, Mike.
As I said, trick question. The 20% is the correct answer. And I will tell you something. Prior to this rule about the 10% withholding, I have repeatedly told other people that I have talked to, other lawyers, clients, never, ever, ever call the 800 number, because you're going to get bad information. People that answer the national 800 number are not well trained, and it is the worst possible place to go to solve a Social Security problem. However, as I discussed on the last slide, Social Security's rules say that if a person is already in 100% withholding because they had an overpayment that predated June of this year, that their remedy is to call the 800 number and ask to reduce the withholding from 100% to 10%. And I also learned from experience when I first started getting clients that were faced with this situation, and I had them call their local field office, that the field office was not instructed anything, wasn't told anything about any of this, didn't know anything about it, told the client I was nuts. And the only way they were able to reduce the withholding from 100% to 10% was to call the national number, 1-800-772-1213. So that is the one situation and only situation where it's advisable for a client to call the national number rather than to try to reach out to their servicing Social Security office. Repayment time frame. Social Security has always been willing to accept an offer to repay them if they would get their money back within 3 years. So when I was talking to clients who might not qualify for reduced withholding based on their finances, so maybe it's one of these retired state employees, maybe they've got money in investments or they got an IRA. I always knew that if I took the amount of the overpayment and divided it by 36 months, and I told the client or to call Social Security and offer them that amount of money per month, that Social Security would take it. Their manual tells them if someone offers a repayment amount that will get us our money back within 36 months, take the offer. You don't have to prove that you're unable to pay it back to do that. They've extended that from 36 months to 60 months. So now when you're talking to someone who for one reason or another isn't going to qualify for a waiver and maybe can't qualify financially, to prove that Social Security taking 10% of their check is a hardship, if they can get an amount that will get Social Security the money back within 5 years, Social Security's instructions are to take the offer without having to investigate the person's finances. There are a couple links to POMS. POMS is the Program Operations Manual System. That's Social Security's manual, which links to the new rules on 36 months versus 60 months if the person makes an offer to repay over that amount, over that period of time. Administrative waiver. This one, depending on who's running the Social Security Administration at any given moment, is sometimes taken offline and sometimes is available online. At the moment, Social Security's policy seems to be more open. So you can find this stuff in POMS and the emergency messages at the moment. That is not to say 6 months or a year from now, that might not change. Social Security always has had a rule that tries to calculate how expensive it would be for us, Social Security Administration, to process the appeal. And if it looks like it's going to cost us more to handle the appeal than the overpayment, then we can waive it just because administratively it makes sense to waive it. And previously the amount was $1,000. So if the overpayment was $1,000 or less, Social Security's regulation said if somebody calls us and requests a waiver, and it's less than $1,000, don't bother. It costs more money to send the client the waiver form and to process the waiver form than for us to just say we're going to waive it. We're not going to collect. They've recently raised that $1,000 limit to $2,000. So be aware if you're talking to a client who has an overpayment of less than $2,000, a lot of times you can get rid of that fairly or easily because of the administrative tolerances. Shifting the burden and showing without fault. Originally, Social Security implied when they were creating this series of reforms on their overpayments policies a few months ago, they implied that they were going to shift the burden to the administration to prove that the person was at fault. They still haven't adopted any rules, but they've apparently backed off of actually shifting the burden from the claimant to the administration. Instead, what they're saying now is they want it to be more fair. So at some point in the future, Social Security is going to issue some kind of regulations, whether it be in their manual or whether it be on a notice of proposed rulemaking, which defines without fault in a way that's a little more fair to the claimant. We don't know yet what that's going to look like. Again, they're in the process of simplifying the waiver form. Supposedly it's going to be 2 to 3 pages. It is not yet available to claimants or even Social Security Administration. Hasn't been issued yet. By the way, the form itself, the one from 2023, one of the questions on it says, is your overpayment $1,000 or less? If you're filling out a waiver for a client, you can change that amount to $2,000 because they haven't updated the form to take into account the fact that administrative waiver allows up to $2,000. Other improvements to come, revising overpayment notices. I'll believe that when I see it. There is nothing worse than a Social Security notice of overpayment. They are incomprehensible. And I'm saying that as someone who worked for the agency for over 10 years. Supposedly they're going to change the auxiliary liability rules. So the 60 Minutes piece that we talked about, where the lady was 15 years old in her dad's home and Social Security said that somebody was overpaid, way back then. She's now getting Social Security and they were trying to collect the overpayment from her. Supposedly Social Security is going to do something to modify or eliminate the rule that auxiliaries are automatically liable for overpayments from the worker. Changes to step 2 of the waiver process, expanding the defeats the purpose financial hardship analysis. Again, that's what I was talking about. What I've heard about SNAP might be sufficient in the future to be considered public assistance so that you don't have to prove that you're unable to repay the benefit. You don't have to give the financial information. And to expand the definition of against equity and good conscience. This is also one of those weird rules that doesn't come up a lot, but this Code of Federal Regulations actually has examples of what qualifies as against equity and good conscience. That was what I was talking about before with person who changed their position for the worse because they went out and bought a car. Social Security has traditionally taken the Code of Federal Regulations examples as the be all and end all of against equity and good conscience. In other words, if you couldn't fit it in to one of the examples given in the CFR, then Social Security would say it doesn't meet the definition of against equity and good conscience for us to collect it. Supposedly, they're going to recognize the fact that against equity and good conscience can include other situations that aren't necessarily defined in the Code of Federal Regulations. Got some resource links here. Social Security has a pretty decent publication online on overpayments. National Center for Law on Elder Rights, NCLER, is a resource that I use quite frequently. They're affiliated with Justice and Aging. They're the ones that did some of the slides that I borrowed here. they have lots and lots of great information on Social Security benefits and specifically on overpayments on their website. There's a link there. I found a nice toolkit from LawHelp.org DC, which is a legal aid program in District of Columbia. Very nice toolkit you can download. It kind of goes through what the client's options are and what they should do. I put a link on here to our fact sheet on Social Security overpayments. I update that myself personally every year. So that's all I have. Thank you for coming. I will be happy to take any questions. And if you want to get your 90 minutes of CLE, I suggest you ask a few questions.
Yep. We're close. We have questions here for the next 5 minutes or so, which should be good. We do have a question, Mike, from Michelle. A lot of clients say they report their government pension in person. Are you able to get a visit log from the office if you have a good guess as to when the person went?
There's a legal answer to that question. And there's a practical answer to that question. When someone contacts Social Security, someone at the Social Security office is making a note in a computer system. It's just like if, we're talking to a client at legal aid, we're making a note in our case management system. Those notes exist. Are they subject to the Freedom of Information Act? Absolutely. Both the Privacy Act and the Freedom of Information Act gives a client federal access to information contained in federal government's computers about their personal situation. Are you going to get it? No, you're not. I would not be trying to. Obviously, if there was a notice sent, that's easy. You can get that from Social Security. But trying to get Social Security to release a note that someone made in their computer system would be nearly impossible to get them to agree to. Not saying you couldn't do it, not saying the law wouldn't allow you to do it, but that would not be my first option.
Okay. I have another question from Kara. What's the best way to get rid of a house that someone's not living in, but is also not as valuable as the auditor lists?
Put it up for sale. Brief story. Recently, the Medicaid rules changed because of litigation that we did. Because Medicaid was counting real estate or any asset for that matter as available asset to a person if it wasn't otherwise exempt, even if the person was making an active effort to sell it. We sued Medicaid because SSI rules for years have exempted property if the person is making a reasonable effort to sell the property. So even if the property counts, because the person no longer lives there and doesn't have an intent to return to it, so it doesn't qualify as their residence, if they're making a reasonable effort to sell it and they show Social Security that, then it's an exempt asset. So in the situation you described, where they moved out, they're living in a senior building or they're living in an apartment and they're threatening to cut off their SSI benefits, SSI has a specific procedure called conditional benefits where you can go to Social Security and say, I'm selling it. You got to show proof that you're trying to sell it. It's a little ambiguous about what that proof has to be and how far you have to go to show that you're making a reasonable effort. But you can continue to get your SSI checks even if you have an asset that's countable, as long as you persuade Social Security you're making a reasonable effort to sell the asset.
And then a follow-up from Kara, what could I file if my client claims they were underpaid SSI for 3 months?
You can file an appeal of a favorable decision. So even a favorable decision, we reviewed your SSI case, they will do a redetermination once a year, so just like with Medicaid, you'll get those once a year notices. You can appeal that even if the thing was apparently in the client's favor. Obviously, what you would have to prove would depend on the facts of the case. But the first thing I'd be looking at is appeal. Is there a notice within a prior 60 days that would allow you to file a reconsideration? Alternatively, particularly when you're talking about SSI, there are rules of administrative finality that allow reopening of a case within 2 years for any reason. And so if you have a client who's outside their appeals period and it's an obvious mistake on a part of Social Security, sometimes the best strategy is to simply request reopening, submit the new and material evidence, and show them why they were wrong. And Social Security is usually pretty tolerant about considering reopening, even if you're outside your period to appeal it.
And follow up from Michelle about the log, Mike, of visits. Michelle said, I had SSA employees check their log at a personal conference, but when I asked for it, it seems like it is not available.
Like I said, legal and practical. They didn't have logs when I worked there, so I'm not familiar with that particular concept. But should it be available? Maybe with your Social Security would argue, if you were dealing with the Freedom of Information Act and or the Privacy Act, that because it involves an employee's log, that it's protected information that's not available. But worst case scenario, should they be able to redact the employee's name? And if it's a log that relates to a specific claimant, should the claimant be entitled to that under the Privacy Act? Yeah. But good luck. That's all I'm going to say. You're never going to get it voluntarily from Social Security. You're going to have to file some sort of a formal request with the Social Security Administration in Baltimore before you would even be able to get an answer to that information.
All right, last call for questions.
And we did stretch it out to 90 minutes. So thanks everybody for questions.
All right. Well, seeing none, I think you all have Mike's contact information. So if you come up with something later, feel free to reach out to Mike. And thank you, Mike, for a great presentation and getting us kicked off for the fall series. Again, a reminder that the next session is on September 20th. It's on Medicare, and we'll send out the link to register for that session later today.
Thanks, Melissa. Thanks everyone for attending.
Take care. Bye.
Bye.